Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Law of Torts, from my last video we have started understanding everything related to tortious liability, and in that series this is my second video. Here in this video we are going to understand the famous Latin maxim, that is Damnum Sine Injuria. In my first slide I am going to explain the meaning of Damnum Sine Injuria, and after that we have as many as 8 case laws to understand this concept very clearly. Not taking much of your time, let's get into the first slide. When we are discussing tortious liability, one of the biggest principle that we discuss is damnum sine injuria. This is a famous Latin legal maxim. Damnum sine injuria means damage without injury, or to be precise, damnum here is damage, sine means without, injury means injury, or we can understand this as legal injury. Now, if something has caused loss to someone, but such loss is caused without harming any of their legal rights or infringing or violating any of their legal rights, in that case, tort is not committed, and hence there is no question of paying any damages or remedy. That is what damnum sine injuria all about. So if you look at the ingredients, actual loss or damage, yes, there exists the actual loss. It may be in the form of financial or economical loss, or loss of comfort, or loss of service, or loss of health, etc. Actual loss or damage is there, but such actual loss was without any legal injury. That means there is no legal loss. There was no violation or infringement or breach of any legal rights. That way, legal loss is absent there, or there is no legal loss. Now, actual loss, yes, it is there. Legal loss, no, there are no legal loss because there was no violation or infringement or breach of legal rights. In that case, the question of remedy or the damages doesn't arise. Okay, so there is no remedy. That is what damnum sine injuria is all about, and we are going to understand this concept with the help of lot of case laws. Now, to summarize, an action of defendant caused loss to the plaintiff, but there was no violation or infringement of legal rights. In that case, there is no tortious liability, and hence there is no question of remedy. That's all about damnum sine injuria, and let us try understand this concept with the help of as many as 8 case laws from my next slide. Whenever you hear the term of damnum sine injuria, the first case law that comes into your mind will be Gloucester Grammar School case. What happened here? There was a teacher who was working for a school, and there was some conflict took between that teacher with the management, and the teacher got upset. He left the school and started his own school in front of that very school. Okay. Now what happened? He was a very good teacher. Hence, lot of the students left the earlier school and joined the new school opened by the teacher. Now this caused lot of loss to the old school because the students start leaving. That means they lost fees, etc., and that caused them financial loss. So what did they do? They put a case against the teacher. Now the case comes into court, and court discussed, yes, are there any loss? Yes, there are a lot of loss because students left the school and joined the new school. So the old school, that is Gloucester Grammar School, has experienced a lot of loss. But was there any violation of legal rights of the Gloucester Grammar School? And the answer was no, because the teacher or anyone and everyone in this world can always start a school with whatever legal requirements are to be taken care. Now that has not infringed or violated the legal rights of Gloucester Grammar School. So there was no legal injury, and hence court said there will not be question of any compensation or remedy. So this case law is the heart of damnum sine injuria. I hope my pictures will help you to understand this case law very clearly, and with that thinking I am taking you to the next case law. The next case law that we are discussing here is ACTON versus BUNDELL. ACTON and BUNDELL were neighbors. and Bundell was happily doing some kind of mining operations in his field, and because of such mining operations over a period of time the whole land got dried up. Now that has badly impacted Acton because Acton's well got dried. Now Acton wanted to bring an action against Bundell, so he came to court and said, see, this is what I am suffering from and hence I need to get damages or compensation from Mr. Bundell. Now court analyzed the case and said, yeah, when we look at the loss, Acton has suffered loss because his well got dried. He has experienced the loss of water. But however, was there any injury to his legal rights? And the answer was no. Bundell in any which ways violated or infringed the legal right of Acton in this case because he was just enjoying his legal right over his private land. He can do anything and everything in his private land and he was enjoying his legal right. And if that has caused some damage to Acton, there is no remedy available for the same because there was no legal injury to Acton as such. That is what held in this particular case law. The third case law is also quite connected to water. What happened here? CHASEMORE and Richards were neighbors. Now CHASEMORE, what happened? He had a mill which required a lot of water. However, there was a stream which was giving sufficient water for his mill, so he was enjoying his business. In between, what happened? Richards digged a well in his private property. Now because of this well, the stream water got dried up because Richards' property was coming in between, and when he digged the well, the water flowed to that particular well and slowly the stream got dried up. And as the stream got dried up, CHASEMORE had no option other than closing his mill because for him water was one of the very essential requirement. Now he closed the mill, and as Richards was the cause, or Richards' well was the cause for his closing of mill, he brought an action against Richards. Now the case came into court and court said, yes, CHASEMORE has experienced the loss, that is loss of water, and because of that he had to close mill and that caused a lot of financial loss also. But however, what was Richards doing? He was enjoying his legal right. It was his private land and he digged a well in his private land, and that any which ways has caused any kind of violation or infringement of the legal rights of CHASEMORE. When there is no legal injury, there arises no question of remedy. That is what held in this particular case law. The next case law that we are discussing here is Mughal Steamship Company Limited versus McGregor, Go and Company. What happened here? There was a steamship company by name Mughal and they were enjoying tea carrying trade. So they were charging certain amount of freight charges for each shipment, and few other steamship companies came together and made a kind of cartel saying that okay, we will fix the freight charges like this, we will reduce the freight charges completely and knock off this Mughal Steamship Company from the business, and they all reduced the cost of shipment. Now Mughal Steamship experienced lot of loss, and because of that financial loss it came to court and put a case against all other companies. And here in this case law the court held that yes, there were financial loss to the Mughal Steamship Company. However, all the other companies who came together, they had their right to fix the price for such shipment and they have enjoyed their right. In any which ways they have caused any kind of damage to the legal rights or violated the legal rights of Mughal Steamship Company, and hence there is no question of remedy whatsoever. As there was no legal injury, no question arises as to compensation. That is what held here. But remember one very important thing, it was happened in the year 1892, but now we have lot of things related to competition law, so that will be seen in a different ways. But that's not the question here when you are discussing about tortious liability, damnum sine injuria. Remember, here there was financial loss to Mughal Steamship Company, but as there was no violation or infringement of any of the legal rights of the Mughal Steamship Company, there is no question of remedy, which is what decided by the court. I hope that is very clear. With that, I am taking you to the next case law. The next case law is a very important. The importance of malice in tort is also discussed in this case law. That is Mayor of Bradford versus Pickles. Now here what happened? Pickles had a land and he wanted the Bradford Corporation to buy his land. But due to some issues they couldn't buy his land and he got angry, and the water supplied by that corporation was passing through Pickles' private land. And what did he do? He digged a well and ensured that the underwater got dried up. Now because of the land of Pickles, the corporation couldn't supply sufficient water to the entire corporation. So the mayor of Bradford put a case against Pickles saying that his digging well was with a malice intention. He wanted us to buy the land. Just because we haven't bought the land, he digged a well, and that is causing a lot of issues to the entire corporation now. Hence we experienced loss and we need remedy. That is what the mayor of Bradford argued for. But the court said, yes, you have experienced damage in the form of loss of water. However, what was Pickles doing? He was enjoying his legal rights. He digged a well in his private property. He had all rights. Now we doesn't see what kind of intention he had. Whether it is malice or not, we don't mind, because as far as it is his land, he has rights over his land, and whatever right he has enjoyed, that is legally right. So that way there was no violation or infringement of any of the rights of the mayor of Bradford or the corporation. So hence there is no question of remedy, which is what held in this particular case law. The next case is Day versus Browning. What happened here? The plaintiff was enjoying the name of Ashford Lodge for his property for almost 60 years, and there was one more property in the same vicinity in the name of Ashford Villa. This was there for almost 40 years. Now suddenly the defendant, that is Browning, changed Ashford Villa to Ashford Lodge. Now this act of defendant caused a lot of annoyance to the plaintiff or Ashford Lodge owner, that is Day. Now he put a case saying that the defendant's act has caused loss to me because a lot of people are getting confused and it is creating a lot of annoyance, hence I need compensation. But the court said no, the defendant named his property in the way he wanted to name it. Now he has used his legal rights to enjoy his property and he has not caused any infringement or violation of your legal rights, and hence there is no question of any kind of remedy, which is what held in this 1878 case law. But then today we have copyright law, so this can be seen in different ways if it is copyrighted, but that's not the matter here. For understanding tortious liability, you can refer this case law, that is Day versus Browning. The next case law is very interesting, that is Burt versus Imperial Gas Company. What happened here? Burt had certain business which had a very clear visibility from the road, and then what happened? Over a period of time, Imperial Gas Company came to his neighbor, and as this is a gas company, they had to erect gasometer and they just did it in front of Burt's shop. Now they have taken care of all legal requirements before putting the structure of gasometer whatsoever, but then it troubled the visibility of Burt's shop. Now Burt experienced loss, so he put a case against Imperial Gas Company saying that because of such structure by Imperial Gas Company, visibility of my shop got reduced and hence I am experiencing financial loss, which is what Burt said. But the court said, yes, you have experienced financial loss or the visibility loss to your shop. However, what did Imperial Gas Company do? They enjoyed their legal rights. They have taken care all the legal compliances required, and they have erected a structure in their private property, and if that is causing some problem to you and causing some loss without harming or violating or infringing any of your legal rights, there will not be question of any remedy for the same. That is what held in this particular case law. And one last case law, that is Quinn versus Latham, is in the line of Gloucester Grammar School, and here a lot of discussion happened related to competition. So that's the end of this presentation. and I will see you in my next presentation with another very important and interesting Latin legal maxim, that is injuria sine damnum. That will be our third video in this series, that is tortious liability. And for now I am handing over this presentation to Nishan.
I thought pulling of legs was only done by human beings. But what are these birds doing? Haha! With that, I am concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.